Is an autopsy report and testimony about an autopsy by a person who did not perform it a violation of the Sixth Amendment right to confrontation? To find out, you have to read People versus Ortega, but it's 18 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Ortega. The citation for this case is 2023, New York Slip Opinion 05956, published by the New York Court of Appeals on November 20th of 2023. The issue in this case is whether autopsy reports and testimony by a medical examiner who did not perform an autopsy about the autopsy violates the defendant's Sixth Amendment confrontation rights. To understand and appreciate the background of this case, you have to just know that the Sixth Amendment to the United States Constitution, it's in the Bill of Rights, guarantees a criminal defendant the right to be confronted by his accusers. And that includes the right to cross-examine witnesses against the defendant. So a witness's statements, testimonial statements, can only be admitted for the truth when either the witness appears at trial for cross-examination, or if the witness is unavailable at trial, that the defendant had a previous opportunity to cross-examine the testimonial statement, the person who was giving testimonial statement previously. So you have to have the right to cross-examine either now or before. The important case in this area is called Crawford versus Washington. It's a United States Supreme Court case that gave more meat to the bones of what testimonial means. And they say that testimonial statements are solemn declarations or affirmations made for the purpose of establishing or proving a specific fact. This includes statements that were made under circumstances that would lead an objective witness to believe the statement would be available for use at trial. So if a statement is made with the concept that it might be later used at trial, that's testimonial. If it's trying to prove a specific fact that's at issue in the case. The last thing you have to know is that there's a prior Court of Appeals case called Facenet, People versus Facenet, that held that autopsy reports are not testimonial because there's not a specific defendant in mind. There's just raw data. There's a couple of things that Facenet based it on that said autopsy reports are not testimonial in nature. Okay, so what are the facts in this case? The facts are that in 2012, the defendant in this case, Ortega, was employed as a nanny for a family in Manhattan with 3 young children. On October 25th of 2012, the defendant nanny brought 2 of the children into the bathroom and killed them, stabbed them to death. The defendant was arrested and charged with 2 counts of murder. She conceded killing the children, but asserted that the devil made her do it. That she actually asserted a defense of not guilty by reason of insanity. We call this an NGRI, not guilty by reason of insanity, NGRI. Autopsies were performed on the children, performed by Dr. Hayes, who was the medical examiner who performed the autopsies, and he made diagrams of the injuries and issued a report. But at trial, the prosecution did not call Dr. Hayes about his observations and what he did. They called Dr. Susan Ely, a different medical examiner who reviewed the diagrams, photographs, the report to give her testimony about what the autopsy revealed. The defendant objected to the autopsy being admitted and to the testimony of Dr. Ely, saying, "I have a right under the Sixth Amendment to confront my accusers and to cross-examine the person who made the observations. This violates my Sixth Amendment right." The Supreme Court, the trial court, overruled the objections, allowed the testimony and evidence, and the defendant was convicted of both counts of murder. The defendant appealed. The procedural history is she appealed, but the appellate division affirmed the lower court's ruling, found that the autopsy and the witness testimony did not violate the Confrontation Clause based on that Facenet case that said it's not testimonial. Goes to the Court of Appeals, and here we have a reversal, an overruling of their previous decision. They say that subsequent to Facenet, after Facenet, the United States Supreme Court dealt with 3 landmark cases in this area about Confrontation Clause and what it means to be confronted with your accuser. And as a result, based upon what those other cases held, Facenet is not good law anymore. They said, why? Because statements do not need to be inherently inculpatory or directly accuse the defendant of wrongdoing to be testimonial. That's what those Supreme Court cases have shown. They're also not saved by being a contemporaneous record. One of the bases of FaceNet was that the record into the report was a contemporaneous record. It was while the doctor was performing the examination, he was writing his observations or dictating them. That does not change the analysis here. It does not protect it from being Confrontation Clause violation. And lastly, they say that scientific testing is not excluded from the Confrontation Clause concerns, that Sixth Amendment requires the reliability be assessed through one specific means, which is cross-examination. So to say that it's based on science and therefore it's reliable does not save it from Sixth Amendment violation. So they're overruling FaceNet. So as to the autopsy reports in this case, they say they are testimonial. Why? Because they are declarations and affirmations made to establish or prove some fact. What's the fact? The homicidal nature of the deaths. Because the reports are asserting that it's a homicide, they are testimonial. And they were made under circumstances that would lead a reasonable witness to conclude that they'd be available and used at a later trial. That makes them testimonial. So specifically, the important quote here is, "We hold that an expert medical examiner may offer conclusions as to the cause and manner of death and surrounding circumstances where the testifying expert performed, supervised, or observed the autopsy or used their independent analysis on the primary data." And they recommend that autopsies, in this decision, they recommend that autopsies be recorded and photographed to enable subsequent medical examiners to conduct their independent analyses based on this raw data. And that's the case of People versus Ortega. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.